Can I ask you a variation of the hypothetical black box scenario that the government puts forward in there? And you might be familiar with it. It's in their brief. So they say that we've got two boxes, each of which continuously fires bullets after the operator presses and releases a button. If I hear you correctly, or maybe you can just tell me, box one, the operator pushes the button and the bullets come out automatically. Box two, the operator holds his finger slightly above the box, and there's something, under the box that pushes the box up into his finger. So the finger is touching the trigger like a million times because in order for it to operate, the box is going like so, pushing up. One is machine gun, one is not. Same rate of velocity of bullets coming out. That's your view.
The answer to that question depends on what is the trigger.
Okay.
And can the holding of United States against Camp, that Fifth Circuit decision that said motorized trigger devices are machine guns, can the rationale of that case be extended to this hypothetical? So I think the way to think of this, Your Honor, is there are going to be easy cases at each of the extremes, and there are going to be harder cases in the middle. The easy case is United States against Camp, because that is a situation where the trigger was changed. It no longer is the curved metal lever. It's instead the switch.
But I guess,
everyone agrees with that.
And your view is what makes it easy or hard is not the sort of thought of mine that, like, geez, what makes it easy or hard is actually distinguishing those two in the real world, like in terms of what is actually happening. You think what makes it easy or hard is just identifying whether the finger is moving because the box is moving or because the person is pushing it down.
What makes it hard is whether it's changed the nature of the trigger in some way. Clearly that happened in Camp. This situation with Mr. Cargill, there's not even an argument that the trigger has been changed. Neither DOJ at no point in this litigation has argued that bump stocks change the nature of the trigger or change the trigger at all. There will be harder cases in the middle, such as the forced reset triggers and some of these hypotheticals that were discussed in the D.C. Circuit's opinions in Guetti's, where there may be a question as to what exactly the trigger is, and then how does that trigger function. So, again, going back to Camp, when there's a flip of a switch that turns on a motor, and that motor then forces the curved metal lever back and forth, that's automatic fire, that's a machine gun, because we now have a new trigger, the switch. It's no longer the curved metal lever. So can that rationale be extended to some of these hypotheticals where we talk about black boxes and oscillating buttons? What exactly is the trigger there? Is it merely the button? Is it the motor that's moving the button up and down? It's arguable either way. We don't think the court should resolve any of that. I understand, but for us to take a position on the question, it's all going to depend on whether you can extend the holding of Camp to these new situations. The Aikens accelerator is a good example to think about, because in 2006, when ATF changed its position on the Aikens accelerator, ATF initially approved that device in 2002. 2006, it changed its mind. And if you look at the classification letter, their argument rests on an argument similar to what Mr. Fletcher is making today. They cite the legislative history from Carl Frederick and say that function of the trigger means pull of the trigger. That rationale is not going to work if the Aikens accelerator is going to be characterized as a machine gun. What might work, though, is if there's some possible argument to extend the holding of United States against Camp to the Aikens accelerator. Does that spring in the Aikens accelerator change the nature of the trigger? That's the question that needs to be addressed. If ATF wants to continue to characterize the Aikens accelerator as a machine gun, it's going to need to come up with a much better argument than what it offered in 2006. We're not closing the door on that possibility, but we do think the actual rationale that ATF has used is just as faulty as the rationale for banning non-mechanical bump stocks.
Thank you, counsel.